Let's complete our discussion of the DMCA by looking at Section 1201A2, which prohibits an individual from trafficking in any technology, product, service, device, or component that is A, primarily designed to circumvent a technology that effectively controls access to a copyrighted work, B, has only limited commercial significant purpose or use other than to circumvent a technological measure that effectively controls access to a copyrighted work, or C, is marketed by that person with that person's knowledge for use in circumventing a technological measure that effectively controls access to a work. 1201A2 is specifically focused on the trafficking of technology designed to circumvent access controls protecting a copyrighted work. If you think back on A1, that was the technology exists. Now we're looking at A2, that we're trafficking in that technology. So the scope of 1201A2 has been interpreted both narrowly and broadly by various courts. We see this in all the electronic crimes laws. Some courts interpret the laws very broadly, and some interpret them very narrowly. The narrow approach in the case of 1201A2 requires that a nexus between the access that is violated and the the protection of the copyrighted work exists. So in other words, there is a access protection. It's broken, it's violated, and access is given to the copyrighted work. The opposing view applies to technology that circumvents the controls that are used to protect that copyrighted work, regardless of whether the technology is actually used to access the copyrighted work itself. So the broad view just says the technology exists, even if you can't show or don't need to show that it was actually used to circumvent some copyrighted protection. Each of these two approaches developed their own 6-point test to determine if that approach should be applied. In the courts that used the narrow test, the plaintiff must prove that there's ownership of a copyrighted work that was effectively controlled by a technological measure that third parties can now access without authorization in a manner that infringes a right protected by copyright, because a product the defendant designed or produced primarily for circumvention and made available only, even if it was only for limited commercial significance, it was marketed for use in circumvention of the controlling technology measure. So in essence, you could see here that nexus. I have a copyrighted work, it has an access control, that control has been circumvented, giving access to the underlying material, which infringes on in a way that infringes on my right to protect that copyrighted material. In the broad approach, the broad test that's applied in some courts, the plaintiff must prove that the defendant trafficked in a technology or part thereof that is primarily designed, produced, or marketed for or has limited commercial significance other than circumventing a technological measure that effectively controls access to a copyrighted work. So you can see how this is much more broadly defined. You don't have to show any actual circumvention took place, just that the technology was capable of circumventing the access control that protected the copyrighted material. That because of these two definitions or tests, the broad test and the narrow test, or more importantly, the broad interpretation by courts versus a narrow interpretation by courts, certainly gives you a feeling that either the defendant or the plaintiffs are going to try to shop for certain venues that will tend to support their level of argument against the opposing person. Section 1201B1 states that no person shall traffic in any technology that is primarily designed or produced for the purpose of circumventing protection afforded by a technological measure that effectively protects the right of a copyrighted owner, has only limited commercial significance, and is marketed by that person for use in circumventing protection afforded by the technological measure that effectively protects the right of the copyrighted owner. Comparing Section A2 with Section B1, Section A2 applies more broadly to the circumvention of technology, regardless of whether the circumvention aids infringement, and B1 applies more narrowly, focusing on the technology that does aid in the copyrighted infringement. So in A2, you have that variation that says you don't have actually any circumvention taking place, where in B1 it's much more narrow. There must be copyright infringement. Certain exemptions can be applied to the anti-circumvention provisions, such as making short portions of motion pictures available for criticism or comment. You see this all the time in presentations that people make, where they'll take a small snippet of a movie or a video and show that for a point they want to make in their presentation. It's fine, but I would suggest that you still cite your reference and cite the owner of the copyrighted material, just to protect their right to that material. You can also have computer programs that enable smart televisions to operate, and certain lawfully acquired video games also have some exceptions. So the argument against the DMCA comes from those who argue that the First Amendment might apply here, that software code is speech. And by prohibiting certain types of software code, that the 1201 censors the speech and therefore violates the First Amendment. For instance, researchers, security researchers, may write code that helps them find vulnerabilities in software or protection capabilities. And if the rules of the DMCA are applied, they would be pretty risk averse to avoid prosecution and civil litigation that might arise if they show that there are vulnerabilities in the software, and that their software has the software that they've written to prove that actually then circumvented the access controls to be able to get to the vulnerability or to prove the vulnerability. And there have been cases of researchers that have found flaws in copyright protection, which were threatened with lawsuits if they actually produced their results or made presentations on their results, published their research, etc. And one case that comes to mind is on Universal City Studios Inc. versus Corley, where Corley published the DCSS on his website, 2600.com, and then set up links to the host site elsewhere in the internet. But DCSS, the only purpose of the code was to defeat the CSS protection on copyrighted DVD movies. Now, again, this was produced only for the purpose of defeating that technology, so certainly you would think that 1201 would apply in this case. So how do we analyze whether or not this is a valid First Amendment claim? Does this law regulate speech? And if the law regulates speech, is the law content-based or content-neutral? Now, if it's content-based, it'll only survive a First Amendment challenge if the government demonstrates that it serves compelling government interests by the least restrictive means that are available. In other words, you're saying that the content of the speech or the software code serves a compelling government interest, in most cases, if it's content-based, more than likely won't survive that First Amendment claim. If it's content neutral, on the other hand, there's more that has to be proven. It has to further a substantial government interest unrelated to the suppression of free speech, and the law is narrowly tailored so it does not burden more free speech than necessary. So to be content neutral, certainly a higher bar has to be met to be able to show that there's a violation of the First Amendment that could be applied here.